Well, I'd like to thank Dr. Bozian for that insightful analysis, and I'd especially like to thank Dr. Bozian for taking down Donald Trump, because personally I'm fascinated by him, because like you, I can't wait to hear the next dumb thing that comes out of his mouth. I want to thank Professor Xi for having the courage to share his story with the American public. I think it's so important and so timely. So thank you, and I want to thank the Asian Law Caucus for putting on this event, or maybe I should blame them for having me follow these two brilliant speakers. Very hard act to follow, but I'll do my best. So I want to talk a little bit about the Japanese-American internment during World War II. It happened a long time ago, but regrettably it's probably more relevant now than it's ever been, because these two gentlemen, having spoken before me, really raised the question, can it happen again? And I think the answer is yes, it can, and it's happening to various degrees right now, right here. On December 7th in 1941, Japan attacked Pearl Harbor. The next day, and Dr. Xi, you could relate to this, Secret Service and FBI swept into Japanese-American communities all along the West Coast, from Seattle to Los Angeles down to Arizona. And immediately, the leaders of that community were arrested and taken away. And their families, of course, did not know where they were going, whether they would see them again, and no doubt experienced the same terror that you experienced and your family. Within days after that, Executive Order 9066 was passed by, or proclaimed by, then President Roosevelt. And it gave this entire area, the West Coast, put it under the command of a general named John L. DeWitt, who spun out and was the architect of the internment from the Presidio. And within months, Americans of Japanese ancestry, and these were 120,000 people, 70,000 of whom were born in this country, they're American citizens by birth, became subject to his orders, and what began as a curfew, they couldn't go out after 8 p.m. at night, had to be in their residences until 6 in the morning, ultimately turned into orders to report to assembly centers. In this area, it was Tanforan Racetrack, which is now San Carlos Shopping Mall. But at that time, it was a racetrack. It was surrounded by barbed wire and machine gun towers. And Americans of Japanese ancestry from the Bay Area were herded there with only that which they could carry in their two hands. They had to abandon their property, their jobs, all that they owned, and so on, in this mass roundup, indiscriminate roundup. And one of the laws, speaking of not thinking, you know, that as Professor Xi was, where the government's not thinking, Congress passed a law. And they basically bisected the entire western halves of Washington, California, and Arizona and Oregon, and declared that an excluded zone for which Americans of Japanese ancestry were subject. And the law said, whoever shall enter in, who shall remain in, or who shall leave this excluded zone is guilty of a crime. So you can imagine, if this is an excluded zone, and generally it was, but imagine this room as being the excluded zone. You cannot enter the room. Well, you're already here. You can't remain in the room. Okay, so you'll decide to leave, but the law says you can't leave. So where does that leave you? That means you are no longer have the rights of an American citizen. And that was the plight of Japanese Americans. There were 3 individuals who challenged those orders because by the end of 1942, 120,000 people had been herded into internment camps constructed in the most desolate regions of America, stretching from California to Arkansas. And 3 gentlemen refused to do it. Gordon Hirabayashi in Seattle, Min Yasui, a lawyer in Portland, Oregon, and Fred Korematsu right here in the Bay Area. And not knowing each other, each refused to obey the internment orders. The government defended their claims on 2 grounds. One, they claimed the Japanese Americans were engaging in spying. Again, something Professor Xi could relate to. And engaging in espionage and sabotage in the form of signaling enemy ships from shore. And the other argument was that Japanese Americans were so different, so unassimilated, so culturally distinct and unassimilated and unassimilable, that they were prone to disloyalty. That was the argument. And on that basis, the cases marched up to the Supreme Court. Fred's was heard in 1944. And that time Fred believed he would get justice, maybe like you did, Professor Xi. But to his amazement, the court ruled against him, 6-3, holding that the internment was not a racial discrimination, but was justified by military necessity. Now that was a term that was used in 1944. The equivalent today is national security. And basically, without questioning the Army's claims that Japanese Americans were spies, they simply accepted it. And that case stood for the next 40 years. Justice Jackson wrote a dissent in that 44 decision, which basically said, the court for all time has validated the principle of racial discrimination and of transplanting American citizens. The principle then lies around like a loaded weapon, ready for the hand of any authority who can put forth a plausible claim of an urgent need. What do you mean by that? It means without a trial, without charges, without evidence of any kind, you can round up an entire racial group and imprison them. Obviously, constitutionally take away their rights. And that case was roundly criticized by scholars and historians as a civil liberties disaster. The case then stood for the next 40 years until Professor Peter Irons and a Japanese-American researcher by the name of Aiko Yoshinaga stumbled upon, by accident, Fred Korematsu's Justice Department file that had been stored without much thought in the archives of the Immigration and Naturalization Service. Well, and sealed in a box. And why would anybody put him in INS? And the reason was that Americans of Japanese ancestry, again, 70,000 of whom were American citizens, they were all declared enemy aliens. And in the government bureaucratic way, anything with alien on it goes to INS, right? And so these things were boxed up and forgotten about. And so in the 1980s, Peter's over there, Irons, thinking he's going to do like historical piece on Fred's case. And among the top documents were Justice Department lawyers. And these were people responsible for preparing the government's brief to argue in the Korematsu case in 1944. And among them was a memo by Edward Ennis, the person responsible for supervising the brief, saying to the Attorney General, we found, or I'm privy now to reports from the Federal Bureau of Investigation. J. Edgar Hoover says, there is no signaling going on from shore to ship, and we've investigated everything. We found a report from Navy intelligence which had primary jurisdiction for so-called national security on the West Coast regarding the Japanese-American problem. And that report was issued before the war saying, we've identified everyone who could possibly be dangerous. We know who they are. We've already arrested them. And there's no need for this mass racial roundup. They are no more dangerous than the German, American, or Italian American population, and they should be handled individually and not on a mass racial basis. There were other reports from the Federal Communications Commission that basically said, from the FCC chair, which said we've investigated every ship-to-shore signaling, and we found that General DeWitt's men are largely illiterate. They can only read 10 words a minute. They pick up signals emanating with loop antennas, and they're picking them up from Tokyo, and they're reporting them to their commanding officer as shore-to-ship transmissions. and he passes them on to the general, meaning General DeWitt, without giving any thought. And these were all made available to General DeWitt and Justice Department lawyers all through the internment and before these cases were argued. And so there were two Justice Department lawyers that are having an ethical revelation. They said, we cannot lie to the U.S. Supreme Court. What are we going to do? And one of the memos says, there's no doubt that the Army's claims that Japanese Americans are engaging in espionage and sabotage are, quote, intentional falsehoods. So the Edward Ennis and writes to Herbert Wexler, the Assistant Attorney General, and also to Francis Biddle, then the Attorney General of the United States, and to the Solicitor General, Charles Fahey, saying, we have in our possession reports that contradict the Army's claims that the Japanese Americans were committing these acts of espionage. Since this is highly unfair to this racial minority, that they should be treated this way, it is our duty to disclose this to the court, and any other course of action it occurs to me that any other course of action might approximate the suppression of evidence. Now, I'm not making this stuff up. I mean, I'm basically quoting these memos. There were a whole stack of them. And so on that basis, and just to round out the story, after making these reports, the higher-ups ignored them. And so what these two lawyers tried to do was insert a footnote in the Korematsu brief. And the brief goes like it is today. It's printed in a booklet. It goes to the printing press. And the War Department, and they put in a footnote that basically said, we have in our possession authoritative reports from our own intelligence agencies which contradict the Army's claims that the Japanese-American internment was justified. It doesn't say we have FBI reports, FCC, it just says to the court, something's not, you ought to question this. And the War Department finds out about this footnote. They literally ordered the printing presses stopped. And we have a memo that says the printing press stopped at about noon. And the footnote was ordered to be rewritten. And after some debate, the footnote read, we have in our possession authoritative reports from our own military agencies, intelligence agencies, that corroborate the Army's claims. And so the last attempt to alert the court that something was wrong failed. And these guys, I give them credit for taking stands, but then they kept their mouths shut for the next 40 years. And obviously, complete subversion of the democratic process. When you have people, I mean, these are not low-level lawyers. These are the highest legal officers in the country. Basically, conspiring, I don't think is the wrong word, to, in some cases, suppress evidence, we found. In one case, they burned it. There's a memo saying, I, Sergeant so-and-so of this division, witnessed the burning of this report that was ordered to be destroyed. And certainly fabrication of evidence. When that happens, what is the future of democracy? Well, there isn't any. And this is the only, I mean, it is a lawyer's dream for me, for us, to find this stuff, because the arguments to reopen that case came not from our pronouncements, but from the government's own files. And so based upon that record of misconduct, Fred's conviction was overturned in federal district court here in San Francisco. The government appealed that finding, that case, and then they withdrew their appeal. They withdrew their appeal. And under our system, only the loser can appeal. The winners don't get to appeal. And so from a tactical and strategic standpoint, we didn't go up any further. But we have lower court cases, also in Gordon Hirabayashi's case, that went up to the Court of Appeals, that basically wipe out, a Supreme Court precedent is supposed to be based on a ruling, it's supposed to be based on real facts. And because this was based on fabricated lies, the whole precedent should, it stands on a foundation of fraud, right? And so the case still is there, but it stands, and I'll just quote this final decision from Judge Marilyn Hall Patel here in the Federal District Court, because I think her statement was wise and prescient. Now, this was issued in 1983, and think of its relevance here today, given what Dr. Bozian and Professor Shia said, as well as what's going on in this country. Quote, Korematsu remains on the pages of our legal and political history. As a legal precedent, it is now recognized as having limited application. As a historical precedent, it stands as a constant caution that in times of war or declared military necessity, our institutions must be vigilant in protecting our constitutional guarantees. It stands as a caution that in times of distress, the shield of military necessity and national security must not be used to protect governmental actions and from close scrutiny and accountability. It stands as a caution that in times of international hostility and antagonisms, our institutions, legislative, executive, and judicial, must be prepared to protect all citizens from the petty fears and prejudices that are so easily aroused. Thank you.